Good morning or afternoon, or I guess even good evening, now that we are operating in some of the Asia Pacific countries. I'm increasingly aware that people are joining us from all over the globe. I was just on an interesting call with a colleague in Europe who deals globally. And when I said Asia Pacific, he said, it's so hard to even use that term, because when you're talking about regions that are so geographically distant from each other, maybe Japan to Australia, and so unique in law and in culture. It's almost, I mean, we need a term perhaps, but it's you're really referring to enormous chunks of the globe and using a shorthand just because you're sitting in Europe or you're sitting in the United States and saying, oh, all that place that's far away. But it's certainly not really a region in the way we should be assuming a lot of similarity and so forth. But I digress. I'm really happy to have with me today one of our star members of the team, Sebastião. Sebastião recently relocated from Portugal to be in residence now in our Brussels office. So we're excited. Those of you who are in the Brussels bubble, I'm sure you'll see him around, because he's not only smart and intelligent, but charming and outgoing. So we're really looking forward to meeting and input and so forth. One of the really interesting pieces of recent work that Sebastião and our global team pulled together is an overview of many of the interesting cases that are in progress on the way to the top court in Europe. For those of us who work in data protection, we sound so certain. GDPR allows this, GDPR doesn't allow this. But the reality is it's still a relatively new law in terms of having jurisprudence. There's obviously been jurisprudence for the predecessor national laws and the European wide directive and so forth. But frankly, it's surprising sometimes how little international jurisprudence there is on some of these issues that are not new. Like, how is it possible that we're still litigating what is a contract and what can be in a contract when it comes to data protection and legal basis and some of these other issues? It's not a brand new concept, but obviously until you have a really serious enforced regime, as we've seen with the enforcement around GDPR, then you first have conflict and you have courts weighing in, and so indeed we are already getting a lot of guidance. Obviously, some of the very famous, cases, Schrems and so forth, but quite a big number of cases that really will shape the contours of the GDPR. So we posted a link to Sebastião's piece. Do take a look at the global area on the FPF blog. Sebastião is part of our global team, and we're putting out a lot of work from this team are really covering many regions of the world. So do take a look at the global blog, and we'll be following your comments and questions here. And please do take a look at this piece in particular. So Sebastião, let's start with some process first. Not everybody is an expert on the procedure, and it's interesting to note that certain cases are able to get to the court or not. A little word or two on how some of these cases end up getting to the court, because many of them are taking a different path.
Yes, that's true. Thank you very much for the kind introduction, Jules, and good morning or good afternoon to everyone who's watching us today. Indeed, some of the GDPR's concepts are not new. There is some case law from the Court of Justice of the European Union also on the concepts that migrated from the Data Protection Directive to the new GDPR, but there are indeed a lot of new obligations, and courts across the European Union are struggling with how to interpret or apply these concepts to concrete cases. And our analysis that only touches upon the pending cases that are relevant from a commercial point of view. We're not talking even about law enforcement cases or cases that do not, touch upon enterprises processing personal data. And there are 18 pending cases, so they are a lot really that we looked upon, and we focused on 8 or 9 that we thought could be more interesting for the audience to follow. So speaking about the process, how does a case, or in this case, a preliminary set of questions by national courts arrive at the Court of Justice, so the highest court in the EU? Just to clarify that this court, the EU Court of Justice, has ultimate authority to rule on the interpretation and validity of EU law. So whenever a national court has doubts about the interpretation and validity of EU law, it cannot rule by itself on that interpretation or validity. It should ask the question to the Court of Justice on how the concept should be interpreted and applied. And in the case that there's no national appeal possible, so if it's the court of last instance at national level, the court, if it has doubts about the interpretation and validity of EU law, is actually obliged under the EU treaties to ask the question to the EU court. And this is how these sets of questions that we'll be discussing today arrive at the EU's judges' desks, let's say.
So the first group of cases that you looked at were focused on things like the right of access, lawful grounds when it comes to processing data for targeted advertising. Let's jump into what are perhaps some that will be most impactful for organizations. Maybe even the lawful basis. So many controversies are around advertising. I mean, this is the sparking flashpoint for concern: too much surveillance, too much personalization, discrimination, misinformation. Yet advertising, essential for businesses to reach users to see what products are out there. But the role that data can play beyond processing to provide the service when it comes to marketing always gets a lot of attention. So what's before the court when it comes to the lawful grounds of processing data for targeted ads?
Indeed. So the Austrian Supreme Court in July this year, so this was very recent, had posed a number of questions to the Court of Justice on what the legal basis for conducting personalized advertising on social media platforms should be. So should the legitimacy or validity of, or lawfulness in this case, of data processing for this purpose be assessed against the standards for contractual necessity or consent? You had a very interesting conversation very recently with Gabriella in one of these sessions in the aftermath of what is publicly known about this very substantial Amazon fine, and what is known is that it is related to some extent to personalized advertising as well, based on the complaint that was filed in 2018 with the French regulator. And this is another case that can at least try to clarify a little what indeed should be the legal basis for conducting personalized advertisement in a way that maybe it's not only third party, but also third party advertising, etc. So if we look at what has been the position of the EDPB in its guidelines on the contractual necessity legal basis in the online context, their position is quite strict, right? So they say that you can only process personal data under this legal basis in the way that is objectively necessary, even from the viewpoint of the user, not necessarily of the controller, to provide the intended service. And then they have very restrictive language on what can be done under this legal basis for behavioral advertising. And I quote, just a little quote: "As a general rule, processing of personal data for behavioral advertising is not necessary for the performance of a contract for online services." So if the court chooses to follow this line of interpretation, it may have an impact on how companies conduct their advertising practices online in Europe, of course. And if we want to,
I want to hold that important point, what you just said, and really flag it, because I find that many people follow some of these controversies and say, well, that's about Facebook. And we know they really have this very broad uses of data, social, it's even the EDPP opinion, it's about, social media, is called out. But when you look closely at what the legal analysis is, I think the interesting point is that it potentially goes far broader, right? We don't know exactly the contours of the Amazon case. As you note from the complaint, it seems certainly the legal basis is relevant. So, but again, Amazon is also a very large, platform where their uses of data may be broader than maybe a news media or another retailer. However, a huge number of even smaller businesses certainly use data that they have, not just about how individuals move around their site or transact. Maybe they register, fill in certain details, commerce-related information. And then upon returning to their site or maybe related sites, some of this history may be used for personalizing advertising. So I guess if I'm filling out, social media and I'm liking and I'm doing all these things, okay, so we can see this is a broad, use, and what legal basis is appropriate here, obviously from companies that don't want to provide an opt-out of this so-called first-party use, right? This is really the issue in many ways. Does this need to be a certain kind of express consent? Right now, you see that sort of more specific consent certainly being demanded when it comes to setting the cookie, when it comes to sharing data through this whole wild, ad tech ecosystem. So we have very clear, guidance that perhaps, even consent may not be feasible to consent to some unknown amount of sharing. But many organizations have sort of a viewpoint that when they don't share, even though they're using the data in a very secondary way, and some of this is a little bit US focused, right? A lot of companies are thinking, oh, if I don't share, anything I can do is fine, right? And of course, that's not the case in terms of even in the US. You still have to live within boundaries of fairness and deception and so forth. You have some secondary use that is sensitive, that creates risks. The FTC has cases where there have been boundaries on this, but certainly from a European and other jurisdictions where you need a lawful basis, you still have boundaries that are dependent based on what your legal basis is. So a good reminder to folks to really follow this case, because it may not solely impact what's going to happen for Facebook or Amazon, but what even a commerce site or what can a publisher do when I'm completing some demographic information? How far can you go to personalize when that personalization is including some commerce? Other thoughts on this, or should we jump to one of the other cases?
No, there's actually a nice link with another case that was brought before the Court of Justice now. So a set of questions by the German Düsseldorf court. In the case, you were talking about the sharing of data for advertising purposes online. And this one is interesting because it is an appeal that was launched by Facebook against a decision by the German Competition Authority, in which it found that Facebook had allegedly abused its dominant position in the social media market by combining data that it gathered through its three major services, so Facebook, Instagram, and WhatsApp. And the court in this case has doubts about whether a regulator, which is not a data protection regulator, it's a competition antitrust regulator, can reach a conclusion that a company has abused its dominant position in the market by assessing its data protection related behavior. So finding a GDPR breach. Can the competition authority find a GDPR breach in exercising its powers, or is it reserved to data protection authorities, such in this case, the Irish DPC? So this is also another interesting question that was brought before the court recently, just to establish the link.
I've been arguing in terms of the US administration, where there's a huge focus on competition, and unfortunately, not a focus yet on advancing privacy legislation. In fact, even yesterday, Lina Khan, the new FTC chair, put out her priorities, and it was very, very heavily competition focused. And of course, this is a dominant issue, but the answer to some competition issues, if you don't have a privacy law, is, okay, so share data or cooperate with data if the concern is some companies are dominating in terms of data. So we've argued you must have a baseline for privacy protection in order to understand whether somebody is violating competition. So I think quite an important case, given that so many of the competition authorities really are taking a big role in the UK. Obviously, we see the competition authority cooperating with the ICO, even around the changes that are being considered by the platforms around, cookies and tracking, and kind of really working in, in tandem. And although in this German case, the regulator seemed to be involved and maybe even supporting or applauding what was going on, it wasn't built on their legal determination, right? The competition authority was assessing. And I think this is an issue we're going to have across a lot of other regulators as well, right? In the US, the Transportation Authority is the lead regulator for privacy when it comes to airlines, which is sometimes surprising to people, surprising to even a lot of US regulators. There's a famous effort by the California Attorney General a number of years ago to go against Delta Airlines because they didn't have a privacy policy for their app. And Delta said, go away, Attorney General, you can't enforce this against me. It's the Transportation Department. And sure enough, in court, they said, yeah. And obviously with connected cars and so many other regulators, obviously, who care about data for safety and care about data for their own purposes. I think we're going to be seeing either cooperation or clashes as these regulators have different views and see their jurisdiction as maybe overlapping. So could be a very important decision, perhaps even beyond competition, whether it's binding, beyond, we'll see, but really could set down what the future of the balance of regulators really is. What are the other top cases that you think we should go to next? Yeah.
So if we keep on thinking about regulators and DPAs, there's also a very interesting set of questions that comes from the Budapest Regional Court in Hungary, in which the court wishes to understand how if a DPA is in parallel assessing the lawfulness of the same data processing operations as a court, what of these two assessments or decisions should prevail. So we talk about the nibis in idem principles of not, sanctioning or censoring companies twice for the same infringement, let's say. What if, for instance, the court decides there is no GDPR infringement and the DPA in parallel proceedings decides that there is? Can it be or can it not? Should the DPA respect the court's views and abstain from, taking its own position, or should it align the position with the courts? And this will be very interesting to see, because one of the corollaries of data protection in Europe is DPA's independence, right? And if this, to my view, extends to their decision-making powers with regards to sanctioning. So if they are bound to take the same views as courts have taken or would have taken in case they would assess the same lawfulness then their independence could be thwarted in some way. And I say this, just imagine if we remember the Schrems, the two Schrems cases in the Court of Justice that were decided in the last few years. It has become quite clear that even though a court may or may not rule that an adequacy decision, for instance, regarding a third country jurisdiction should withstand or not the scrutiny under the Charter of Fundamental Rights, the DPA, regardless of that assessment, still has powers if it deems the third country jurisdiction not to, grant enough protections to the EU citizens' data, they can still suspend the transfers. So even if courts don't see it that way, so I've seen media reports claiming that the DPAs in Europe are some of the most powerful regulators in the world, and given their very broad independence in terms of their decision making, it seems to be so. But maybe after this judgment by the Court of Justice in this Budapest set of questions, we'll have further clarity. Of course, DPAs can decide on sanctions and to fine companies with very large sanctions, and courts in appeal procedures, because companies will appeal DPA's decisions, may still overturn or reduce the amount of fines. And this has happened very frequently in the European space. We can see that in Germany, in which the Berlin DPA, for instance, sanctioned a real estate company for breaching the retention limitation principle for 14.5 million euros, and basically the court said, no, there's no breach here. We won't attribute any sanction to this behavior. So it can be very radical in terms of what comes out of judicial appeals. So there's still obvious judicial scrutiny after DPA decisions, nonetheless.
So speaking of judicial redress, another interesting line of cases is around who can engage in such representative actions. Can a competitor, as well as, what is a non-material damage? Can fear or a worry count as a non-material damage?
This was brought again by the Austrian Supreme Court. It's one of the most active courts in terms of referrals to the Court of Justice, which is commendable. Some courts decide not to ask questions when things are not so clear. So there's this doctrine that has been developed by the EU court called the Acte Clair doctrine. So whenever it is quite clear and unquestionable what the legal act means in terms of interpretation and application, courts are not forced to ask the question to the Court of Justice. But, courts across Europe have different interpretations of what a clear act is. So some are more prone to ask questions than others, of course. In this case, regarding representative actions, Article 80 of the GDPR, specifically paragraph 2, allows where the national laws of the member states provide for it, non-profit associations, organizations, to bring judicial proceedings before courts, even without a data subject mandate, right? But there are a couple of limitations to what they can do. So they must have a specific nature. So they must be non-profits, organizations, or associations that are entitled under national law to bring these proceedings. And they have to have expertise in the field of data protection, so that there's a sort of limitation around this. And another limitation that stems from paragraph 2 is that they cannot ask for monetary compensation to data subjects without a mandate, all right? And basically what the court here is asking the Austrian court is whether where these bodies, competitors, associations are allow under national law to bring proceedings against their competitors under consumer law, should they be allowed to do the same under data protection rules as well? And this is basically the question that is being asked. Of course, if things are, the literature seems to be quite clear on the fact that only the bodies that have that specific nature can bring these types of proceedings. It seems unlikely that the Court of Justice will extend the subjective scope of the norm. It can do so, but it would be kind of a surprise, so at least for competitors, let's say.
We still have cases around the independence of the DPO. We still have rulings around search engine delisting, employee data processing is still in the mix. Disclosing recipients when it comes to access requests. What else we should mention? Data as remuneration. What's that one? I see that went in July to the court.
Yes.
Do you recall what that one is?
Yeah, so that one is a little tricky to dive into because the questions have not been published yet, as far as I'm aware, or maybe it's not that particular case. So this is the case that we touched upon in the beginning of the session, I believe, when we were talking about the legal basis issue and whether we could use consent or contract necessity. So, but speaking about data subject access requests, because I believe this is a very interesting referral that was put forward by the Austrian, in this case, Federal Administrative Court. The court, in essence, wants to know whether the right of access of the data subject comprises obtaining a copy of documents or database excerpts where the personal data is included, or only a faithful reproduction of the list of types of data that the controller is processing. This is interesting because there have been a significant number of cases decided by German courts that in which judges generally take the view that the right of access is not the right of access to documents in itself. So in any case, German judges tend to restrict the right of access of data subjects to allow controllers redacting certain information from documents should they wish to share them to protect their own trade secrets or intellectual property rights, for instance. So it is still not so clear when controllers can avail themselves of an exception to the right of access to protect others' rights, which is the exception that is allowed under paragraph 4. We have seen very recent Spanish DPA decision on the right of access to medical records by patients in Spain, in which the DPA decided that patients don't have a right to access the doctor's personal annotations that it actually includes in the medical records, which interestingly seems to be in conflict with an earlier Court of Justice ruling, the Novak ruling, in which the court decided that students have a right to access their students' personal annotations in their exam sheets, right? So it of course, it has to do with medical confidentiality and basically ethic rules around healthcare processing of personal data. So that cannot be present in another case. But in any case, it seems to be interesting how national instances, even DPAs, can conflict with the Court of Justice jurisprudence. And there is also, just to wrap up on the access part, because I believe this has many layers, that we have also seen a tendency of Dutch courts to not extend the right of access to obtaining very detailed information about profiling and automated decision making when it comes to gig economy workers. So we have seen courts in the Netherlands reject Uber drivers' requests to access some of their personal data that was used by Uber's algorithm that matches passengers and drivers, on grounds that the request made by the drivers was too general, as in it didn't specify the specific categories of data they wish to receive. So it basically only granted the plaintiffs access to their anonymized individual ratings and not other pieces of information, such as how Uber tagged their or labeled their behavior in their internal systems, for instance. This is also another dimension of why this reference to the court is so interesting, to actually understand the extent to which data subjects can access the information held by companies on them.
Really important cases. You know, on the access side, this is going to be a place where there is interesting history on enforcement and judicial cases when it comes to health records, because although it's hard to get the access because companies don't cooperate quite well, you do have, you know, significant access rights under HIPAA to your health records and also your education records. And so there's been lots of cases over the years that have helped define the parameters of that. The states that are passing in the US consumer privacy laws are carving out employee data. California included it, but then pushed off a little delay, which if the delay expires, companies are now looking at, do we need to get ready to provide employee data access? That would be a new thing and a very big thing, because the DPAs that I talk to in Europe all tell me that, oh, you see a lot of drama in the news with the big tech and advertising and all these things. The drama we've always had for a long, long time as a right that individuals have exercised and takes up a lot of our time is indeed employees who are terminated or who have concerns with their employer, who are making access requests. And so quite an area where there's a lot of history already about the scope. Okay, folks, you all have to go back to work, or hopefully happy hour or whatever you're up to. Sebastião, thanks for taking the time. Folks, I recommend a read of the blog post. I also recommend, for people who really want a big overview, the court puts out very regularly its own sort of summary of all data protection cases, and it's always a very good read. Maybe we can post a link to it also in the comments. I find that every time they update it, I don't know that they have these most recent ones that we've all captured here. These are all the pending ones, but they do a good write-up of multiple years of their jurisprudence, and I always find it interesting to use that as a good refresher of how the courts sort of sees their own jurisprudence evolving. Thanks for everyone who listened in. Really good to see you. Stay tuned. We'll have some announcements soon about the annual FPF and VUB Brussels Privacy Symposium, which will be coming up. So you'll see some details. Our focus will be on AI regulation, and we have some very prominent participants. So stay tuned. And Sebastião, thanks for joining me. Bye, everybody. Happy Friday.